Well, good morning, gang. Welcome to our special edition of Money Matters. Now, I say it's special today because I've been, for those of you that have been popping on regularly, you've probably seen Jackson talking about, the things that we know wealth creation is. And it's quite interesting when you actually look at the big picture. And since I've been working and talking to Jackson, he's actually taught me some stuff that, wasn't front of mind. And today's topic is something that maybe you have never even talked about. Now, maybe you're cleverer than me and you would have spoken about it with your family and friends. But what I'm going to talk about today is get Jackson to give us an overview of what estate planning is, how it helps in wealth creation, because I didn't know about it and I didn't have a plan in place. But guess what? Now I know, and now we can fix what we don't know. So welcome, Jackson.
G'day, mate. Thanks for having us again.
Mate, look, the goal that you've been sharing has been outstanding, and some of the things that we have let's say a fictitious overview on.
Yeah.
You're making it sound, well, there is a Pandora's box, but if you know how to open it, it can be harnessed. And one of the things that we were alluding to a little while ago is having a plan.
Correct.
And if we don't have a plan, we're going to plan to fail, especially if we're just getting advice thrown at us left, right, and center. And one of the things that popped up just a couple of weeks ago was the thing called estate planning.
Yeah.
I wonder if you tell the listeners what estate planning is.
Yeah, look, estate planning is probably one of the most often overlooked aspects of most people's overall plans. I think most of us are so focused on plan A, what are we really working towards when everything is going to plan? But many people overlook the importance of having a plan B. And as part of our foundations framework, we call it the F3 framework. We essentially make sure that all of our clients have what we call a plan A and a plan B. And there are 6 key pillars, each 3 in plan A and 3 in plan B, that allow us to establish a really solid financial foundation. Now, our plan B comprises of having a really solid emergency fund or a war chest, having the right risk management strategy, and then also backing that up with a solid estate plan. Now, an estate plan is essentially a strategy that you have in place where there is something that comes unforeseen. It is either a death, a total disability, or some sort of catastrophic unforeseen event that will result in either the transfer of wealth or the protection of wealth for your benefit in the event that you are no longer able to make decisions for yourself. Now, this is a pretty grim subject, Steve. So I hope people don't switch off, because this is often the biggest risk that most people...
I find that with grim subjects, we avoid the conversation. It's like when you go into business. Everyone says, oh, it's going to be terrific. We're going to be best friends. We're going to have a marriage made in heaven. But the solicitors will say, well, hang on, what's the exit plan? What happens if you have a fallout? And a lot of people don't have the planning. Now, it is grim, and we hope it's not necessary, but estate planning is not just about grim, is it? It's actually having an exit plan or a plan of action, and it's not always about property. It's about a whole lot of other things. It's like having a will. We all need to have a will, but many people don't.
Yeah. And I think this is the analogy I always use is that you draft your divorce papers before you get married. And because it's the best time to do it, is when your emotions are in the best possible position to ensure that you consider all of the possible eventualities, that if things do get heated and things do get out of hand, that you've had the agreement made when you were in sound mind. The same thing happens with estate planning. And I'll tell you guys a story that I had a really terrible experience happen to me personally in relation to estate planning. And this is something that I'm super passionate about. Now, my old man was a very dominant personality, and he didn't take advice very well. For years, I begged him to make sure that he got his estate plan sorted, because my old man had been married on a number of different occasions. We had a blended family, and there were a lot of moving parts. For that reason, it was extremely important that he had a really good estate plan. And he kind of heeded my advice. He did go to a solicitor and get his estate plan done. But here's the thing, guys. You don't know how good your estate plan is until sometimes it is too late. Now, in my father's situation, he got some advice, and the lawyer was not an estate planning specialist. They wrote the documents in a particular way whereby after the fact they could be contested. And after his unfortunate passing, we had everybody coming out of the woodworks trying to get a slice of the pie. As his executor, it personally cost me over $80,000 out of pocket to have to fight off the claims made on the estate. Because here's the kicker, guys. In estate planning, and the often overlooked factor is that everything that you have written has to be completely quantifiable with no ambiguities, because you are likely no longer around to be able to explain what you meant. And if there is a slither of a doubt around the interpretation, then a battle ensues.
Now, does that need to have the lawyers, or is it got to be a combination of people that understand finance to make sure there's nothing that's sort of be ambiguous?
Correct.
So it actually marries with the law and have specificity, which will make it real.
Well, it's about understanding that there is a estate planning law in Australia states that any eligible beneficiary has the ability to make a claim on an estate whereby they feel they are entitled to something. And if successful, they can fund their claim, so their legal costs, from the estate itself.
Whoa.
Which basically means that anybody who has a crack at the pie can do so almost scot-free.
Gee, that's a golden nugget. I bet you most people don't know. So if there's the untimely demise of a family member where you're part of that will, and if it's not been written correctly, in other words, there's nothing that's ambiguous, someone can say, I'm going to challenge it, and it's going to come out of the estate if it's got funds. Is that right?
Correct. Exactly. The legal fees are funded from the estate, meaning that there is zero barrier to entry for people to have a crack. And what often people do is that somebody passes away, they go get some legal advice, and there are sometimes some legal representatives that may not carry the right values, and they essentially urge you to make a claim on the estate, or urge other people to make a claim on the estate.
So
Now,
they'll get paid from the estate, doesn't come out of your pocket. And whether you win or lose, you've at least given it a crack because there was an ambiguous phrase, or let's say nothing that was quantifiable.
And here's the thing, guys. There is nothing you can do in regards to your estate plan to stop this happening. However, having a good, solid estate plan can ensure that if it was ever contested, without a slither of a doubt, your instructions and what you wanted to see happen was unquestionable. And this is about making sure that we have the right estate plan, and we have the hard conversations now. We get the right advice. We get the documents written in the right way that ensure that you have peace of mind and certainty around the people that you love and care about getting the money that they deserve in the event of the unforeseen. Because this is what this is ultimately all about. This is about intergenerational wealth planning.
So as to be able to pass the baton on to the people you want to pass it on to. Correct. And so many people, I've actually asked the question over the years, have you got a will? And they say, oh, yes, I've got a will. And it's just a few little lines and so forth drawn up and say, oh, Bob will have this and John will have my car and so forth. I've not seen a lot of specificity in that will. Is it a estate plan married to the will?
It definitely is. So the backbone of your estate plan is really two key things. The first one is your will. And the first thing is that if you've got a will that's been done from the post office will kit, or a template that you found online, or even your suburban solicitor that is a bit of a jack of all trades, then it is likely that your will is insufficient to be able to cover for all contingencies in the event of your unfortunate passing. Like anything in life, when we talk about something that carries such significant implications and repercussions, we need to work with a specialist. We are estate planning specialist facilitators, where we help to facilitate the process, and we work with estate planning specialist lawyers to ensure that our clients go through the motions. Because what we often find is that we say, hey, Steve, need to go get your estate plan done. I'm going to refer you to Bob, the estate planning lawyer. And you're going to go, sure thing, Jackson, I'm going to go do that. And you never do it, because it's a horrible thing to think about. So we hold our clients accountable to going through the motion. So the cornerstone of everything is getting the right will. The second thing is having a binding beneficiary nomination on your superannuation fund. In 9 out of 10 instances, when we do research on our client's superannuation, and we spoke about super a couple of weeks back, that 9 out of 10, individuals do not have a binding nomination on their super. They either have no nomination at all, or they have what's referred to as a non-binding nomination. Now, let me explain this. Your superannuation with a binding nomination has the ability to bypass your estate, meaning that any super that you have and any insurance held within inside that super can be paid directly to a beneficiary or beneficiaries that you nominate. Now, a binding nomination requires a couple of things. It requires the official binding nomination document that your superannuation fund provides, and it requires you to have two independent witnesses that sign the document to verify that it is in fact binding. And it also typically needs to be updated every 3 years. Now, the common pitfalls that many people find themselves in is one, they update their beneficiaries online. It means it's not binding. Two.
Oh, so they go online to do all this activity, which a lot of people have been told, getting used to doing. It's not binding. Whoa.
No. And the problem is that the super funds don't educate you around the implications. It's bad on their part, but the reason is they don't want to open up a can of worms. Second thing is that they inaccurately or in error get the documents witnessed. They sign in black pen, someone else signs in blue pen. They sign on the 28th and the witnesses sign on the 29th. They only get one witness. And all of these things result in the document not being binding. Now, here are the implications of having a non-binding nomination. If it's binding, the super fund must pay out that benefit to the individual beneficiaries that have been nominated. If it is non-binding, the trustee of the super fund will take into account the people that have been listed, but they need to provide an opportunity, typically by way of publishing an obituary notice. They need to provide a window of opportunity for other people who may be eligible beneficiaries to step forward.
Oh, dear me. So if you don't have all that stuff, you can then have the people, they will call them vultures, trying to jump in and grab the thing that you didn't want to take place. Gee, this is... Look, I'm sure many of you guys out there have not heard about this.
No one's ever heard of it. And most people only hear about it when it's too late. Now, here is the best case scenario in that outcome. Best case scenario, it takes longer for your beneficiaries that you've nominated to get the money. Worst case scenario, somebody comes out of the woodworks who is deemed by the trustee to be an eligible beneficiary and they get a slice of the pie. Let me give you an example, Steve. I had a client years ago, very early in my career, who came on board with us. It was very, very early in the process. So we actually didn't get an opportunity to get to the point whereby we'd been able to do all of this stuff. We were still in research phase. And there was a husband, a partner, they weren't married yet, and they had a young child that was probably about 3 months old. Husband unfortunately passed away. Didn't have a binding nomination in place. He had a non-binding nomination that he'd never updated to his ex-partner from years past. Because she was nominated, even though he had a new spouse with a child, the ex-partner got the majority of the life insurance and the superannuation payout, and unscrupulously took the money without any second thought.
So is that because he was naive and just didn't know, he didn't know what he didn't know?
He just forgot that he never updated it. And because it was a non-binding nomination, it was up to the trustees to make the decision of who they believed the eligible beneficiaries to be. And they chose the previous partner over the new partner with the 3-month-old child.
I'd love to ask everyone out there that's listening right now, how many of you guys know that you need to have a binding nomination as the beneficiary of your super? I wonder how many people actually know that. Did you know that? Well, I can tell you right now. I reckon that most people would say, what's that? Because superannuation don't say, hey, these are the sorts of things you need to do once you've signed up with us, because they just want to get the super gig. Wow.
Exactly, 100%.
Rock.
So next thing, we've got our 2 pillars, our binding death benefit nomination on our super and our will. These are the 2 key parts of your estate. And for majority of people who have a relatively straightforward situation, these are the main 2 things that you need. The next things are nice to haves, but they have a substantial number of benefits for particular types of people. So the first one is referred to as a testamentary trust. So Steve, have you ever heard of a testamentary trust before?
No, I've never heard of testamentary trust.
Sounds real fancy, right? Now, a testamentary trust is a trust structure that is an optional clause in your will and has throughout history for the last few hundred years been a mechanism, a wealth transfer mechanism for the super wealthy. However, in the age of technology, the costs associated with including these things in your estate plan have been drastically reduced. Now, let me give you a scenario. In your will, you unfortunately pass away. Your estate dictates that you nominate an executor, somebody who project manages your estate, and you nominate beneficiaries who receive your estate. Once that estate is finalized and that money has been paid out, the will is finished and there is no policing of what happens with those proceeds. Let's say, for example, you have young children that are under the age of 18. You don't want to leave them these huge sums of money, right? One, they're not in a position to manage it. And two, whoever is managing it, how are they being policed to ensure that they're managing those funds appropriately for the benefit of your children? This is where a testamentary trust comes in. A testamentary trust is a structure that comes with a rule book that holds a trustee accountable to making sure that they manage the funds appropriately for your beneficiaries.
What's the ramifications if they're not?
They are bound by trust law and they can be criminally prosecuted.
Wow. Okay. This is really interesting, especially if you've got siblings.
Correct. This is perfect if you've got young children, you've got spendthrift beneficiaries, or you've got beneficiaries that are in high risk positions. They run businesses, they have high risk occupations, and things where there is a high chance of litigation. So we have a rule book. We can say, okay, we want the kids to go to a certain school. We only want the money to be used for specific purposes. Little Billy and Mary can only get access to the money when they're 25 and they can actually start making some smart financial decisions, because we don't want Billy and Mary when they turn 18 to go out and buy Porsches and Ferraris, right? Because I know if I was 18 and I inherited a whole heap of money, I'm sure that's probably what I would have done. So we can protect your beneficiaries from themselves. But here's the kicker, Steve. Children in Australia who receive investments and earn investment income, any kids under the age of 18 can only earn about $300 a year in income.
$300 a year?
$300 a year. Anything that they earn above that, they end up paying about 65% tax.
Jeez.
And the reason for this is that so the super wealthy in the world don't put all of their assets in their kid's name and pay less tax. Okay. It's essentially a mechanism to stop people engaging in tax avoidance. However, if you've got a testamentary trust, every single beneficiary of that testamentary trust is deemed to be taxed as an adult, irrespective of their age. So this means that if you've got a couple of kids, Billy and Mary, you've left them, say, $1 million from a life insurance policy or your assets in your estate, that's invested in producing $50,000 of income. You could split that income proportionately across Billy and Mary and they would pay next to no tax.
Well, these are types of things that I'm sure that people don't ever talk about. I mean, talking about your nomination for your super, was it testimony trust?
Testamentary trust.
Testamentary trust. Yeah. And then making sure that you're connecting your will and your super together. I mean, this is estate planning, especially if you're, looking to create a family, have a family now, even if you have, a mum and dad that are wanting to look after you when they pass away. It's something that needs to be discussed.
Correct. And here's the thing. The testamentary trust provides us with some other benefits as well, Steve. This is where we really start creating intergenerational wealth. This is where the biggest families in the world, your Murdochs, your Rockefellers, all of these big names are using these vehicles to transfer wealth from generation to generation. And it's much easier for people like us to get access to it because it's much more cost effective now. Here's a great kicker. If we have a testamentary trust and we leave money to our kids, those kids grow up, they get married, subsequently divorce, then any money that we've left in that testamentary trust cannot be touched It cannot form a creditor asset if you get sued. It cannot form a divorce asset if you separate. So it will only get passed to lineal descendants. Go to your kids, to your grandkids, and potentially even their kids. This is where we pass wealth from generation to generation, as opposed to it getting eroded along the way through to things that life just throws at us.
So if you have one of those trusts, those testamentary trusts, that will then be passed over through the family. It doesn't have to be reset up. It stays there. It just gets passed over to a different trustee. Is that right?
Exactly. And it can run for up to 80 years. And 80 years is a long time. And that's 80 years from the event of your passing. So this is something that's just, the clauses are there, the rules are there, ready and waiting for the event of the unforeseen. Because these are things that we need to think about now.
Yes. I think it's absolutely critical that I'm so glad we're talking about it, because there'll be a lot of people out there that have their businesses, they're sort of, they need to have some planning in place, and they have never even heard of this, let alone all the things that you've just spoken about with the nomination with the super, linking the wills and the super together, and obviously these, say the word again.
The testamentary trust.
Testamentary trust. It's a new word for me. I've got to get it in my head.
That's all right.
So, what's the first step to get this estate planning in place?
Yeah. So the first step is we need to consider our wishes. What do we want to see happen in the event of the unforeseen? Now, in my book, I have a chapter on legacy, and it's about going through the process of understanding what do you want your intergenerational wealth plan to look like, and also going through what we call an instruction sheet, where we express what we want to see happen in the event of different scenarios. Once we've got that, we then review what your current estate plan might be. So we review, do you have a binding nomination in place? Let's get some quick wins. Let's go download the form from the website, get it sorted, get it witnessed, get that locked away. Really quick and easy. If you've got an existing will, let's get an estate planning lawyer to review it and give you views on if legislation has changed, if there's any rules that have changed. Does it actually reflect your wishes? And are there any gaps or risks associated with your current situation right now? And then we normally will get a quote from an estate planning lawyer to say, okay, Steve, based on your goals and what you're trying to achieve, based on the complexities of your situation and the things that we need to put in place for your estate plan, this is what it costs. And the reality is it's not as expensive as most people would think.
So it just seems to me, and I think everyone's hearing this loud and clear, and I just want to just make it loud and clear, is that it's not hard to have an estate plan, but you've got to speak. And I think this is the big boomer. You've got to talk to an expert. You've got to have somebody that understands about estate planning, but also can connect you to the lawyers that understand the new laws, and also to then have those different types of trusts and nominations and so forth, and do the small things first and then move through that. Because if we don't use an expert in that area, you're just going to get something that's quite feeble and won't stand the test of time. And I hear this loud and clear from what you're saying, because a lot of these things I've never heard of either. So I'm not any type of person of an expertise, but I think the things you're saying is you have to have an expert and someone who's in a financial coaching organization that actually can steer you in the right direction, because referral is far better than actually looking in the on Google or on the good old yellow pages.
Exactly. And look, the hardest part here, and I think the most important part here, is bringing your family together to have the hard conversations up front. Because the reality is that we're not sitting around the kitchen table talking about these things. Unless somebody's facilitating this for you, this is the unspoken rules that most people don't talk about: death and what happens in the event of their untimely demise. And it just, unfortunately, it's just a part of our culture that we don't talk about it, but it presents a lot of risks. And the most value that we add is that we've sat down with big family groups and been able to facilitate these conversations to be able to uncover problems that would have cost hundreds of thousands, in some cases millions of dollars, as a result of not having those conversations up front and not getting the right legal advice and the right documents put into place.
So once that's all been had that conversation and we get the experts in place, question I've got here, how often should these estate plans be reviewed?
Yeah, we'd say that we want to update them and review them whenever there is a significant event. So for example, married, divorced, new kids, significant buying and selling of assets. These are all main triggers for reviewing the estate planning, or otherwise every 2 to 3 years.
Is that with the lawyer, or would that be with our financial coaching institution?
Yeah, really, it's about getting back to the lawyer typically, and basically saying, look, this has been the change in my situation. Has this impacted the way that my documents have been written? Do we require to update them?
Right.
A good estate planning lawyer will typically not always itemize every single line item in your assets and liabilities for that specific reason, because they don't want to have you come back every 6 months having to update it and when things change, right? And further to that, many good estate planning documents are written in such a way whereby it says, hey, these are your current children and any other biological lineal descendants. So if you have another kid, it's not necessarily don't necessarily have to update the documents if they've been written properly, but it's always worthwhile to kick the tires on it and make sure that they're up to date.
Now, I know you have a very tight inner circle, Jackson, and not many people can get in there, but it sounds to me that you've got some estate planning lawyers inside your corral, so to speak.
Yes, definitely do. We've got estate planning lawyers that we've vetted. We know are specialists in the area. We know that do good work. Their documents have been time tested. And ultimately, this is the biggest risk, guys, is that you don't know how good these documents are until you put them to the test. In the example of my father, it took us 18 months to resolve and $80,000 out of my own pocket as a result of not getting the right advice. And it probably would have cost my old man $1,500, $2,000 to get, based on his situation, the right legal advice. So to spend $2,000 to potentially save 80 and a lot of stress and anxiety in the process, I'm sure that would have been a good investment.
So what's the next step, mate? So look, I'm sure people are going, gee, well, what do I do? What do I do? I think it's, I think they should be having a discussion with yourself and your team to say, well, what's in place now? Have you got that binding nomination on the good old super? Do you have a will? All those sorts of things. And if you've got a family, then have an action plan to take to the lawyer. I'm hearing, and correct me if I'm wrong here, if the plan hasn't been set out first and going to the lawyer, then you're wasting money. I think they've got to talk to, let's say, your team and yourself to have a plan. So then they go to the lawyer. It's all good to go.
Well, here's the thing, guys. You can grab a copy of the instruction sheet in my book, and essentially it's under the legacy chapter, that basically goes through all of the questions, all the things you need to do to pre-prepare. In addition to this, we can help you review not only your plan B and not just the estate planning, but review your overall foundations. Because while you're at it, you may as well spend a bit of time looking at your plan A, your plan B, making sure you've got the 6 key pillars that form your financial foundation sorted and give you that solid base to build upon. Because here's the thing, guys, none of us make good decisions when there's uncertainty. And if you do not have a solid plan B in place, consciously or subconsciously, it will be affecting the way that you go about your financial decisions into the future. It's just, I've seen it time and time again that although most people have been procrastinating about getting this done, once it is done, the sigh of relief that most people have to know that that is in place, their kids, their partner, their family are all going to be taken care of, it definitely impacts your forward-facing decision-making and the way that you go about your plan A. Just get it done.
Look, I think most people procrastinate because they just don't know what they don't know, but also don't know where to go. And that's why this Money Matters that we're talking about now is we're making the things that people don't know what they don't know, and they now need to say, well, it can be sorted out. And there's so many people that say they can do so many things, but they haven't gone through the test of time. But you guys have, and look, this is absolutely absolute gold. And if the guys wanted to get your book, how could they do that?
So you get access to our referral partner gift page. So we've got creating killer cash flow training that all of you guys get access to. As part of that, you also get a free copy of my book. So all you need to do is jump onto that page. Steve will chuck it in the comments. Register for a copy of my book. We'll send you out a hard copy, and you can of course book in a time to catch up with us, and we can have a conversation around how we help you moving forward.
That's awesome. Now, what chapter should they go to for the estate planning? Have you got
under chapter 5 in the foundations component, it's part of plan B, legacy planning and estate planning. So we cover that all off in here, and you'll be able to get a very comprehensive view of the overall estate planning process and the key things you need to consider.
Awesome. So I'll grab a link from you. We'll pop it into the comments and we'll help those people out. Mate, look, this has been absolutely fantastic. It's a can of worms, but you've managed it to make sure it sounds something that can be fixed by firstly having a plan and then talking to the right people. And as you said, everyone's going to have a lot of peace of mind when they're done and dusted. So thanks so much, mate. It's absolutely awesome.
Happy to help.
Guys, interesting topic, hey? Did you know about that stuff? Look, I certainly didn't. What are you going to do about it? I'm going to put these links down the bottom, and I want you to click the link, get that book, have a chat with Jackson though, and I'm going to put his email in there. Now, he didn't say to do it, but I think if you really just want to do the damage, just click the button, have a quick chat on email, organize a chat with Jackson and one of his team. They're unbelievable in a circle, and take some massive action. Procrastination is the thief of opportunity and time. So I'm Dr. J. We've given you some great stuff with the great man Jackson. He's just so generous with his ideas and strategies. Take some action at what makes things happen. All right, guys, we'll see you soon. Bye for now.